Hello everyone, welcome back to LiveLaw. I'm your host Shambhavi, and today we are diving deep into a topic that affects all of us, but many may not even realize it. Surveillance in India. Whether it's phone tapping, monitoring emails, or tracking our movements, surveillance is everywhere. But did you know the legal framework that governs this in India? Today we'll break down India's surveillance laws in simple terms. So stick around till the end because you won't want to miss any of this. In a recent controversy, PV Anwar, a ruling MLA from Kerala, has accused the Chief Minister's political secretary and ADGP MR Ajit Kumar of illegally tapping his phone. Anwar claimed that the Kerala Police's intelligence wing was involved in intercepting his communications without proper authorization. He raised concerns about misuse of power and invasion of privacy, stating that the phone tapping was politically motivated. This allegation has sparked a debate on surveillance overreach and privacy violations. The state government, however, has denied the accusations and no concrete evidence of phone tapping has been made public so far. Over the years, there have been several high-profile cases related to phone tapping and surveillance issues in India. Like in 2019 and again in 2021, reports emerged that Pegasus spyware developed by the Israeli firm NSO Group had been used to target smartphones of various individuals globally, including journalists, activists, lawyers, and politicians in India. Pegasus is a highly advanced spyware that can infiltrate a device without the user's knowledge, accessing personal information, messages, calls, emails, and even turning on the camera and microphone. In response to concerns about privacy violations and illegal surveillance, a group of petitioners approached the Supreme Court of India. In October 2021, the court formed an independent expert committee to investigate whether the government had used Pegasus spyware to surveil its citizens, raising critical constitutional questions related to the right to privacy. The Pegasus case highlighted gaps in India's legal framework for surveillance, especially regarding emerging technologies. It raised questions about oversight mechanisms for state surveillance, the need for stronger safeguards to protect the right to privacy in the digital age, the role of judicial intervention in regulating government surveillance. Again, in March 2021, phone tapping allegations surfaced in West Bengal during the assembly elections. It was reported that conversations between political leaders and election strategists were being intercepted and leaked. In another case, in July 2020, Rajasthan witnessed a major political controversy when the Congress government led by Ashok Gehlot accused the BJP of attempting to topple the state government by poaching MLAs. Audio tapes were leaked, allegedly containing conversations between leaders of both the parties. Again in 2018, during the investigation into the Bhima-Koregaon violence and the alleged Maoist links of activists, it was reported that several activists' phones and computers were under surveillance by central law enforcement agencies. Human rights activists claimed that state was using electronic surveillance as a tool to target and monitor those who opposed government policies. In another such incident in 2019, WhatsApp confirmed that it had informed Indian authorities about a security breach in its platform where around 20 Indian journalists, activists and lawyers were targeted using the Pegasus spyware. In the Elgar Parishad case, it was reported in 2021 that the laptops of several accused activists had been hacked and manipulated before their arrest. A forensic report revealed that incriminating documents were allegedly planted on their devices using malware. In February 2020, the Delhi government accused central agencies of tapping the phones of senior leaders and bureaucrats without authorization. Another important ruling came in response to a 2022 Delhi High Court order which required a Nigerian national, Frank Whitus, accused in a drug case to share his Google Map locations with the investigating officer. The Supreme Court ruled that bail conditions requiring constant tracking of an accused's location, such as dropping a Google Maps pin, violate the right to privacy under Article 21 of the Constitution. The court found that such conditions would virtually confine the accused even after release, undermining the purpose of bail. The judgment, authored by Justice Abhay S. Oka, emphasized that constant surveillance by law enforcement is an infringement of personal privacy. Now, surveillance is not a new concept. Governments have always monitored communications, but with the digital age, things have become far more complex. To regulate this, we have several laws in place. Let's start with the grand old Indian Telegraph Act of 1885. This act is one of the earliest laws governing communication. Section 5 is particularly important because it allows the government to intercept communication like phone calls if it's in the interest of public safety or maintain order during an emergency. The key phrases here are public emergency and public safety, which are pretty broad, allowing the government significant room to justify phone tapping. However, this power comes with a check. Interception is supposed to be authorized by a designated authority, usually the Home Secretary, and it's only supposed to be used when necessary. But as you can imagine, the interpretation of necessary can sometimes be questionable. Moving on to a lesser known but equally important law, the Indian Post Office Act 1898. Now, this may seem outdated because who uses postal mail anymore, right? But the government still has the authority to intercept postal articles under this law if it deems it necessary for national security. Now, fast forward to the digital age where emails, messages, and online activity has taken over. The Information Technology Act 2000, especially Section 69, empowers the government to intercept, monitor, or decrypt any information transmitted via computer resources. Under this section, the government can monitor our online activities, but like the Telegraph Act, it requires proper authorization. If you're thinking, well, I use encrypted messaging apps, so I'm safe, think again. The law requires service providers to assist the government in decrypting any information they want access to. This means even your encrypted chats could potentially be read if the government deems it necessary. The question of privacy versus state control became a hot topic in India during the hearing of the famous Aadhaar case, J. Puttaswamy versus Union of India. In this landmark case, the Supreme Court had to decide whether the right to privacy is a fundamental right under the Indian Constitution. But laws are only one side of the coin, and privacy is no longer an alien concept, but its definition and boundaries in India are still evolving. India has developed several advanced surveillance systems like NETRA, NatGrid, and Central Monitoring System. Let's talk about the tech behind surveillance. Developed by the Defense Research and Development Organization, this system monitors internet traffic, scanning social media, emails, and more for suspicious activity. It tracks suspicious keywords on the internet such as bomb, attack, or terrorism to detect potential threats. A far more advanced system, NatGrid connects databases of various agencies providing real-time access to information about any individual. This is particularly useful for counter-terrorism operations. Finally, the Central Monitoring System is the big one. It intercepts and monitors all telecommunications, and even though it's designed for lawful interception, the sheer scale of its capabilities makes it a powerful tool in the hands of the government. These projects were questioned during the right to privacy case, where the argument for privacy became stronger due to the potential misuse of surveillance powers. Government initiatives like Aadhaar, Digital India, and other biometric programs were scrutinized for their role in mass surveillance. Now let's circle back to the legal framework that governs the surveillance. Along with the laws we have discussed, we have Telegraph Rules 1951, which lay down procedures for intercepting communications. For example, Rule 419A specifically deals with authorization for interception. The important thing to remember here is that while there are guidelines in place, the actual process of interception remains opaque. The public has very little visibility into how often these laws are used, making it difficult to challenge surveillance overreach. Now, I think it's time we talk about phone tapping, one of the most controversial forms of surveillance. As already mentioned, over the years, there have been several high-profile cases of phone tapping. Remember the Neera Radia tape scandal? For those who don't, let me give you a quick summary. The Neera Radia tape scandal involved the leaked phone conversations of corporate lobbyist Neera Radia with prominent journalists, politicians, and business figures. The tapes, recorded by the Indian Income Tax Department as part of a surveillance investigation, exposed her alleged influence over government decisions, especially regarding the allocation of 2G spectrum licenses. The tapes implicated Radia in several ways, raising concerns about corporate lobbying, media ethics, and the nexus between business and politics. The scandal led to widespread public debate but no significant legal consequences for those involved. It highlighted how phone taps could be leaked and misused. Despite this, the laws governing phone tapping remain unchanged, leading to concerns about misuse. Let's understand the procedure for phone tapping. The primary legal framework for phone tapping in India includes Telegraph Act 1885, Telegraph Rules 1951, the Bharatiya Nyaya Sanhita 2023, and Information Technology Act 2000. Interceptions can only be carried out with prior authorization from appropriate authorities. For central agencies, this typically involves the Union Home Secretary. For state police, it involves the State Home Secretary. In urgent cases, law enforcement agencies may carry out interception with an order issued by an officer not below the rank of a Joint Secretary of India who has been authorized by the Union Home Secretary or the State Home Secretary. However, they must be reported to the Home Secretary within 3 days, and the interception must cease if not ratified within 7 days. In remote areas or for operational reasons, if it is not feasible to get prior directions, law enforcement agencies may carry out interception with the approval of a senior officer not below the rank of Inspector General. LEAs must submit a detailed request for interception, including reasons for the interception and specific communications to be monitored. The request is reviewed by the Home Secretary or their delegate to determine if it meets legal requirements and if there are no alternative means to obtain the necessary information. Once authorized, the interception is carried out by the designated LEA. The interception must be done in a manner that respects legal limits and safeguards privacy to the extent possible. The law enforcement agencies must document all aspects of the interception process, including the reasons for interception, the scope, and the outcomes. Periodic reports are submitted to oversight bodies to ensure transparency and accountability. Individuals who believe their rights have been violated through unauthorized interception can seek legal redress through courts. The court can examine the legality of the interception and offer remedies if necessary. As we talk about surveillance, we cannot ignore the widely debated nothing to hide argument. It's often said, if you've done nothing wrong, you've got nothing to hide. But this argument is flawed and can be problematic. While many may not perceive a threat to their privacy, it's important to recognize that surveillance can go beyond catching illegal activity. Legal experts argue that the constant monitoring of law-abiding citizens could still be a violation of personal freedom. Despite the privacy paradox where people appear willing to compromise their privacy rights in practice, the growing public awareness after the Puttaswamy judgment highlights the need for a comprehensive re-evaluation of India's surveillance laws. This same argument was brought up during the right to privacy hearings. Former Attorney General Mukul Rohatgi argued that privacy is a foreign concept in India and people aren't as concerned. However, this is changing as more people understand the implications of mass surveillance, and the Supreme Court's recognition of privacy as a fundamental right has sparked new discussions around how far government control can go. India doesn't have a comprehensive data protection law yet, but the Puttaswamy judgment of 2017 recognized privacy as a fundamental right under Article 21 of the Constitution. This should, in theory, limit how surveillance is carried out. However, without clear laws defining the scope of privacy versus state surveillance, the balance is tricky. Justice Puttaswamy versus Union of India, as already discussed, the Supreme Court recognized privacy as a fundamental right under Article 21, right to life and personal liberty. Surveillance laws often invoke national security, public order, or crime prevention as grounds for restricting fundamental rights under Article 19. However, these restrictions must meet the test of necessity and proportionality to avoid arbitrary state action, ensuring they don't infringe on the right to freedom of speech and expression. The People's Union for Civil Liberties (PUCL) versus Union of India case laid down procedural safeguards for telephone interception under Article 14, right to equality. The court mandated that interceptions must be governed by established legal procedures to prevent abuse of state power, ensuring that citizens are treated equally and fairly before the law. The Constitution guarantees due process of law. Article 21. Surveillance without judicial or parliamentary oversight, as often seen in mass surveillance systems like NETRA or NATGRID, raises questions about the violation of this principle. Surveillance can lead to a chilling effect on citizens' freedom of speech, expression, and association. If people feel they are constantly being watched, they may alter their behavior or refrain from engaging in free speech or political dissent, infringing on their constitutional rights under Article 19, Clause 1, Subclause A, freedom of speech, and Article 19, Clause 1, Subclause C, freedom of association. The judiciary serves as a check on executive power. The Pegasus case brought to light concerns about unaccountable surveillance and whether the judiciary should establish mechanisms for greater scrutiny and transparency in state surveillance activities, consistent with the basic structure of the Constitution, which includes rule of law and judicial review. So there you have it, a comprehensive breakdown of India's surveillance laws. From the Telegraph Act to the latest surveillance technologies like NETRA and NATGRID, the legal framework is vast and powerful. While these laws and systems are meant to protect national security, they also raise concerns about privacy. What do you think? Should there be more checks on how surveillance is conducted? Drop your thoughts in the comment section below. We would love to hear from you. If you found this video informative, don't forget to like, share and subscribe to LiveLaw. Hit the bell icon to stay updated on all things legal, and I'll see you next time.